Okay, the recording has started.
Great. Good morning, everyone. This is Rob Bovat. I'm doing a poor impression of Chair Przonski. He's on the road today and calling in, so he's asked me to just kind of fill in as a temporary chair here this morning. This is the House Bill 3000 Task Force, the Law Enforcement Subcommittee. I know we've got a long and more formal name, but that's what everybody knows it as. Today is October 20th, 2022. It's 10 a.m. And we're going to begin on our agenda with a presentation from Bailey and others about environmental crimes. So I'll turn it over to Bailey. By way of just introduction, I'll let everybody know if, since this is virtual, if folks want to speak or ask questions, if you could raise your hands. And I say folks, committee members, public is certainly welcome to listen in. But we've got a lot of work to do here today, so we're going to largely confine the comments and questions to committee members. So turning it over to Jordan and Patrick, take it away and talk to us a little bit about environmental crimes.
Thank you very much. We very much appreciate the opportunity to speak to the subcommittee today. Before I begin, can everyone see my PowerPoint slides?
Yes.
Thank you very much. So my name is Jordan Bailey. I'm an Assistant Attorney General with Oregon Department of Justice. Specifically, I'm a member of the Environmental and Cultural Resources Enforcement Unit. With me today is my associate Patrick Aitchison, also from the ECRU unit. And we're going to share with you today the work we've been doing over the last year in regard to the intersection between environmental crimes and illegal cannabis. We look forward to the discussion with you today. Quickly, an introduction as to who we are. So ECRU stands for, again, the Environmental and Cultural Resources Enforcement Unit. That unit, in terms of Assistant Attorney Generals, includes myself, Patrick Aitchison, and Jay Hall, who is our Wildlife and Anti-Poaching Resource Prosecutor. We are housed within the Criminal Justice Division, and with us is also we also have a paralegal, an investigator, and other legal staff that support us in this endeavor. Our role in the state is to assist Oregon DAs in the prosecution of crimes that fall under the environmental statutory schemes and as well as other criminal matters that essentially intersect with an environmental nexus. We're uniquely situated not only because of our relationship with our fellow members of Department of Justice and the other agencies and our network of relationships with district attorneys across the state, but we also have extensive relationships with federal partners, out-of-state partners, the state's tribes, state agencies, and their collective resources. Our primary role when we do get involved in these cases is to match the needs of these DA's offices when these issues arise. We can assume a case if they don't have the bandwidth to take any of these cases. We can co-chair cases with them. And if they have interest in prosecuting the case within their own office, we can just provide a support role. We can discuss strategy, we can warn them of the pitfalls of environmental prosecution, and essentially provide whatever support they need as we pursue this endeavor. Briefly, wanted to introduce what sort of the general outlines of an environmental prosecution in Oregon looks like. So the primary bread and butter of what we do are prosecutions involving the Oregon Environmental Crimes Act. The statutory provisions that encompass that act are listed there. Essentially, these are provisions that many of you would be familiar with in terms of the idea of environmental crime, unlawful water pollution, unlawful air pollution, unlawful disposal, treatment, or storage of hazardous waste, etc., as well as a couple specific crimes that have to do with the responsibilities that permitted entities have to DEQ or other state agencies. We also do and review prosecutions under the criminal provisions of a number of state agencies' statutory schemes. So essentially many of our partner agencies, a non-exclusive list of which is right there, such as Water Resources, Department of State Lands, Department of Agriculture, etc. Many of those statutory provisions that guide those agencies have a criminal provision, and often, or not often, but on occasion, they do interact with situations that may or may not be criminal. And we do what we can to help not only guide them with answering that question, but also bridge the connection between the local DA's office to properly make sure that when those situations arise, they are handled appropriately. In these investigations, we also make sure that traditional criminal charges are added when appropriate. If for ECRU to be involved in a prosecution, there must be an environmental nexus. However, if we are being involved in a prosecution, we'll ensure that whatever appropriate criminal charges arise out of the same sort of occurrence that brings us to be involved, we'll make sure that those things are handled appropriately. And again, it's all about discussing the case-by-case situation with the district attorney as that's happening. For us to be involved in a case, it requires us to be appointed as a special deputy district attorney in that county. It's a fairly simple process, and we not only do it very frequently, but if officers are unfamiliar with that process, we help them with that. Really, we recognize that DAs across the state have a different portfolio of resources to give to issues like this. And as we said before, our goal is to make sure that we're meeting their needs in terms of how to make sure that these things are appropriately adjudicated. One important note that's specific to the environmental crime world is that ORS 468961 outlines the process by which DAs and the Attorney General have adopted guidelines that essentially guide the analysis of whether or not it's appropriate to bring felonious environmental crimes when situations that meet that situation arise. There's also a statutory requirement that a certification is filed with the court essentially in the course of any of these prosecutions to ensure that the DA has indeed reviewed those factors and is doing it appropriately. It's a unique thing to the Environmental Crimes Act, and we frequently have discussions with our DA partners about what it entails, when it's required to be used, and really the purpose of that statute is to encourage not only statewide consistency of the application of these crimes to make sure that some counties aren't using it differently than others, but to make sure that when environmental crimes are being considered, that it's an appropriate exercise of prosecutorial discretion.
And I think, to echo Jordan's comments, this is the only place in the criminal code where this provision exists. It's a result of a compromise, but it's meant because in environmental law, there's an intersection between the civil side and the criminal side, and not every permit violation, would be appropriate for criminal prosecution. When we think about unlawful cannabis, we're in a different realm, though.
Exactly. Thank you, Patrick. So in terms of illegal cannabis in Oregon, I put together this slide literally by surfing Google and different local newspapers to snip as many headlines as I could about cases involving illegal marijuana across the state. I think often in these conversations when we discuss how illegal cannabis has changed and affected Oregon over especially the last 10 years, often that conversation seems to focus in certain geographic areas of the country of the state, and it does sometimes have a perception of affecting some areas of, more than others. Southern Oregon obviously is a place that's dealt with illegal marijuana for a long time, but I think one of the things that we've discovered as we've really looked into this question is that illegal cannabis does affect pretty much every corner of the state to some degree. I think if you reached out to your law enforcement partners in every county, I would imagine every one of them has had at least one instance where they've had to manage one of these situations. So it's certainly not a problem isolated to one place. And we have seen over time that sort of the geography of some of these activities is constantly changing. So it's something that even if a county hasn't seen this issue, there's always a possibility it could come up again in the future. Not just marijuana crimes. So when illegal cannabis investigations are happening, it's frequent that other crimes can be involved. And these slides are just pulled just to show some examples. If you speak with your law enforcement partners, not only do firearms crimes, money laundering crimes, many communities have dealt with robberies or assaults that are associated with cannabis activity. It's something that frequently is dealt with when law enforcement is investigating illegal cannabis. But something that a lot of people don't realize is that there are a lot of other, especially in more rural parts of the state, there are wildlife crimes or animal crimes. We've obviously had a lot of discussion this past year over the human trafficking intersection between illegal cannabis and human trafficking issues. What we've seen as we've talked with our law enforcement partners is that rarely is the marijuana or the cannabis aspect of these crimes even sort of the most serious thing going on, or may be a portfolio of things that are affecting the communities that are dealing with these problems. And when we became involved with sort of asking this question of, okay, well, as the folks who focus on environmental crimes, we keep hearing that there may be this possibility or a likelihood of environmental issues happening at these illegal grows. We've been working hard to answer that question of what is the nature of that? Is it really to the degree that we are hearing, and what can be done about it? And the more we've had these conversations and we've reached out to our many partners, it does seem as though that the problem is there. That's what's really brought us to be involved in having these discussions.
It's like Representative Morgan has a question. If you could take a question at the moment.
I can, yeah, go ahead.
Thank you. I appreciate so far all the presentations. So I guess I'm just curious. I met with our environmental health. We have one employee that tries to respond to all the environmental health complaints in Josephine County. And one of the main issues we dealt with, reported this summer, is that individuals swimming in a local swim hole received chemical burns from the runoff from the grow up the way that was identified as illegal. At which level, I mean, to me, the fact that you're harming other people and their health and the chemical burns, I mean, not just to mention the human trafficking and everything else, but at which point is that something you're like, okay, that's serious enough, or that's enough, I guess, to actually go after and have some, or is it just on the local DAs that have to kind of deal with it on local county levels? When is it egregious enough that our Oregon waterways are contaminated enough that people are getting chemical burns? Who knows what's going on with the wildlife?
Thank you. And all of this has been a lead up to talk about truly the environmental crime aspect of this. So there's a lot of that content yet to come in our presentation. In terms of your question of sort of when does it get to that degree, in terms of our analysis of just looking at the nature of the environmental crimes we use, which we'll introduce to you shortly, and when it's appropriate to use, we would say that that bar clearly, in terms of the whether or not to look at that issue, that the issue is one that we want to look at and answer. The question that we've run into is, well, yes, we see that the issue is there, but how do we help law enforcement or the local community actually get to the point where it can be prosecuted by the DA's office? It's not necessarily one of, is it happening? Is it can we build a case that can prove it in a court of law? Because as a prosecutor, your DA office is going to have to not only know that it's happening, but be able to show the evidence to a jury or a judge that it is happening. So when we talk about the elements a little bit, if you have further questions in that regard, I'm happy to re-answer it. But in terms of the things you described, that does indeed sound exactly like a water pollution or another environmental crime. But the question that we keep, and the challenges that we have seen come up when we have that question is an issue of how do we get it to the point where we can prove it in a courtroom. Does that answer your question?
I partially, and I think part of it too is still the nexus of local government versus state government. Initially with cannabis, it was this is a state issue, locals stay out of it. But our local sheriffs had to say, hey, we're having all these other things come about, other crimes related that we are getting engaged, and it is, taking on our local district attorneys and sheriff's offices. But at which point is this, is that the appropriate level, or should it be something at a higher level or a different level? Now, granted, our district attorneys are state offices, not local. They're elected locally in their districts, but they are a statewide thing. But I guess I'm just trying to figure out the nexus of, as state law has said, the state will handle enforcement and prosecution and all that. When is it that?
So I think that one of the emphasis that I have in terms of your question, I believe I'm understanding what your secondary question is there, is that your local DA's office is still going to be that first line of defense in terms of bringing these cases. We are not in a position to swoop in and take cases from local DA's office. We work in tandem with them to make sure that they have the resources that when these unique circumstances come up, that we're able to provide them with the help to prosecute these cases accordingly. What we've found as we continue to do education and outreach with our DA partners and our law enforcement partners is that while because this issue is not a part of the traditional criminal code, sometimes DAs just don't have necessarily the language or the expertise in the environmental side of it to know whether or not they can bring a case appropriately. And sometimes these cases move on extremely fast timelines. So what we've been doing over this past year is trying to put the language in the local DA's hands so that they can bring this accordingly. We want to build on that work and continue to see that it's done. But our goal is to be a support with our DAs and to try to get them to the point where they can assess these fully, to the point where they can make an accurate charging decision instead of just knowing it's happening but not getting the information to be able to handle it appropriately. I want to keep addressing some of this so we can get to some of the content that talk about what you're doing. I can go through these slides pretty quick. I think this is, we talk about our sort of the what this actually looks like. Some people are going to be much more familiar with how this looks than others. You know, for the public and the people who end up in juries, sometimes we find that there's a perception that there isn't as much of an impact as there really is in terms of illegal cannabis activity. And what they don't realize, and what our law enforcement partners have learned, is that truly these are large scale agricultural activities. Sorry, does someone have a question?
Yeah, folks go on mute if you're not speaking. That would be great.
Thank you. So I just have a couple pictures. Land use and clearing, you know, many of our rural counties know that when they have these activities, often this is happening in rural parts of the county to avoid detection by law enforcement. Some of these sites are involving significant clearing of land, whether this is private land or public land. We do see significant activity happening, you know, in rural county property when this activity happens, and sometimes it's done 1 year. Law enforcement's able to deal with the grow, but because of the amount of sort of land destruction that's happened on these sites, it can be sort of prone to new entities coming into these same areas, and habitually problematic sites can occur. We also see significant sort of land movement and dirt movement in terms of making makeshift dams, trying to sort of modify the land, you know, without any permit, without any communication with the local agencies to facilitate crafting these essentially illegal farms. Environmental concerns. So, you know, this is the type of stuff that we have gathered information about in terms of what's actually seen. And again, due to the scale of some of these large scale illegal grows, often what's not thought about is the amount of infrastructure, the amount of plastic, the amount of material that goes into perpetuating these things, and the fact that because they're often in more remote parts of counties, is that once you get all this stuff in there, it's difficult and labor intensive to get out, and obviously puts all this material in a place that's close to more sensitive habitat, to waterways, and to areas where it can affect the environment. Again, a couple photos of some of the things that we see: large scale water use, large scale pesticide use. You can see some generators in these photos. Again, it's about perception of what actually it takes to run these things. You know, something that our law enforcement partners have become all too familiar with over the years. A couple other photos. So this slide, I want to talk a little bit about what we've done over the last year. So one of the biggest things has been education and outreach. We've put together trainings that include this type of material that we're presenting to you today, that we've given to DA's offices, to law enforcement teams who work specifically in this area, to educate them on these environmental crimes. As someone who in a previous role has done cannabis prosecution, I can attest that often in terms of some of these questions, while we knew that there were environmental issues going on, by the time a case came to my desk, I didn't have either the evidence or even some of the full knowledge of what was happening on these sites, to the point where I had enough to make a decision to bring a charge in the first place. And what we're hoping to do is, by putting this lexicon more in the hands of those DAs, that maybe we can start to realize a little bit whether or not these tools that we have in the Environmental Crimes Act can be applied to illegal cannabis. We've also done a lot of work with the Water Resources Department this year, who's, as a result of HB 4061, has been doing a lot of great work in terms of working in tandem with county code enforcement and law enforcement partners to capture the water theft and water appropriation variable to a lot of these cannabis grows. I'm sure you've heard from a lot of those partners, and we've had a lot of great conversations to both educate them maybe more on the law enforcement role and proper sort of criminal procedures that are going in terms of the law enforcement piece of this, and to make sure that they are being a good partner. We really have appreciated that work, and we look to continue to build on the work that they're doing. We regularly discuss specific cases with not only our county DAs, but federal partners. When situations come up where a county runs into a potential environmental crime on illegal cannabis, that we want to have an open line, and we encourage them to contact us if they have questions about cases. It doesn't mean we're necessarily going to take a case. We are happy to be a facilitator and advisor and try to connect folks from one side of the community, the law enforcement side, to the agency side so that we can better answer these questions as we learn how to better apply the environmental lens to illegal cannabis. We also have regular communication with our state agencies on how to improve our enforcement mechanisms and how to improve our collaboration. We regularly discuss our different roles and brainstorm ways that we can improve our practices by being all at the same table and hopefully building on our specific roles in these pieces and trying to figure out how we can get value added from working together on those things. We have had recent discussions that have circled around the idea of an incident response model in terms of those agency collaborations. Obviously, we're always still workshopping things, and there's much yet to happen, but we've been really excited about the conversations that we've been having with our partners in that regard, and we hope to keep building on that. And again, as always, our DAs know that we can assume a prosecution if they don't have the bandwidth and there's an environmental nexus to it. It sounds like there may have been a question.
Well, a lot of this liaison work that Jordan and I are doing is meant to make sure that the right personnel are on site during the execution of a warrant, so that we're able to document what would be necessary for environmental process. Not everyone in law enforcement has a familiarity with these statutes or what would be necessary crimes, and sometimes it does take some technical expertise, someone such as a DEQ or water resource. And so a lot of the work that Jordan has been doing last year is making connections between those agencies and law enforcement.
It's true. Thank you, Patrick. And that leads us to our sort of challenges slide here. We have, in these conversations, we've realized that while in a perfect world, we'd be able to utilize these environmental crimes and add them to marijuana prosecutions when obviously these situations are unfolding. There are a large number of challenges that occur, one of which is exactly what Patrick refers to, is that while we've worked to bridge the gap in communication between these various entities, because of the nature of law enforcement's actions on these grows, sometimes there's sort of a timing needle to be thread in terms of the ability to bring all these folks together. So overall, for those who haven't had familiarity or spoken with those who engage in just traditional cannabis investigations, there's a number of challenges of bringing the right person to justice in a lot of these circumstances. A lot of times it's difficult to identify who the decision maker is involved. A lot of times that decision maker is not necessarily at these sites, that they delegate, whether voluntarily or involuntarily, to other folks to do the manual labor on these. And we don't always know, it's not always clear what these roles are. Often people flee scenes when these things happen, and it's difficult to identify who exactly would have the knowledge of what's going on some of these sites. Sometimes they are found to be abandoned, and law enforcement's left, unfortunately, with just cleaning up the illegal cannabis and not able to identify who may be the suspect in the case. Executing these search warrants are extremely labor intensive. As you can see from some of these photos, there is a lot of plant material alone. And often this is folks going out with really like loppers and equipment and spending whole days in sort of the dog days of summer trying to clean up thousands of marijuana plants. And it's hard to add anything to those plates in terms of the ability to ask law enforcement to investigate other variables to this. And on top of it, often these are in remote locations. And what that adds to this is that if, let's say, they do identify other potential environmental crimes going on, it can be difficult to peel off a member of that team to try to get communication to, whether it be your DA or to an agency partner, to try to figure out how that evidence can be gathered or that problem can be addressed while they're out there. So just some of the logistics alone make it very difficult. Officer safety in a couple regards is really important. One, we've recently had a good conversation in some of these sort of interagency and interpartner meetings that discuss that while law enforcement would love to be able to have the appropriate agency or technical folks to support them on these, it's important that information is divulged at a time where it's not going to put law enforcement at risk in terms of when information is divulged about these situations. Also, in terms of just environmental issues in general, if dangerous chemicals or pesticides or things that shouldn't be handled without the proper training and experience are on these sites. We don't want to put law enforcement in a situation where they are mandated with collecting things without necessarily knowing what they are, and we don't want to put law enforcement in a place where they could expose themselves to some of these dangerous chemicals, which is why, in a perfect world, we have support from those who are trained in handling some of these chemicals, supporting them. We talked about resources. Again, there's just making sure that, as we said, you thread a needle in terms of timing, and we want to make sure that people are together. The collaboration that has happened this summer is encouraging, and that agencies like Water Resources has been able to join law enforcement in a lot of these situations. But it continues to be a challenge to make sure that everyone's at the table. In terms of the question of who can join a search warrant, the law does support agencies being able to support law enforcement when there is a specific, if law enforcement needs a specific person to help them with the execution of a search warrant and to gather evidence, the law does support that. But I do think that agencies have indicated a desire to have that be a clear delineation of when they can and can't support search warrants. So I know that's something that that many members of this committee have discussed in the past. Testing, not only has testing for just marijuana crimes alone been an issue over the last 10 years, and I know that has changed greatly and people have worked hard on those issues, but in terms of our questions, we worry about whether or not law enforcement will always have the ability. If there's a water pollution case, they may not have the technical ability to engage in some of those testing, which is why we want to talk more about sort of what support would be needed for some of these cases. I'm going to start moving pretty quick because I know we only have 15 more minutes. I want to go through some of these statutes. In terms of the definitions here, there's a couple things that are particular to environmental crimes that are unique to environmental crimes. This subsection B of this is what I want to point your attention to here, is that not only in terms of knowingly doing an environmental crime in Oregon, the subsection A is the traditional definition under the law, but the subsection B is something unique to Oregon in that you knowingly commit an environmental crime when a person is acting with a conscious purpose to avoid knowledge of a conduct or circumstance in violation of the environmental law. So essentially, not only are you committing knowingly committing an environmental crime when you physically know that you're aware of the circumstance you're engaging in, but if you're someone who's trying to blind yourself willfully to the actions that are going on and you should be knowing what's going on, then you could potentially be found guilty. The substantial harm or health to human health or the environment is something that is a particular trigger for felonious crimes. It provides a little bit of definition in terms of when it's an element that leads to most of our environmental felonies, and I just wanted to make sure that was put in front of the folks here. Another definition that is specific to environmental crimes here is that someone, just because they're a part of an organization, doesn't mean that they necessarily possess that knowledge that makes them criminally liable. But as we said before, if they should be in a position where they know, they can be found guilty. So it's just another sort of side to that coin in terms of how those are written. To give everyone that lens, this was written with permitted entities that are violating permits in mind. So the organizations of illegal cannabis operations weren't necessarily what was in mind when these statutes were written, but we do think that these statutes are going to be very indicative of how we could use these as law enforcement works to understand these operations. Real quick, just in terms of how DAs and law enforcement can determine the number of offenses, each day on which a violation occurs is a separately punishable offense. Essentially, this was written with the idea of ongoing environmental harm in mind. So every day that law enforcement could prove that something was polluted or something was discharging into a waterway, for example, each day that's happening could constitute a different offense. For water pollution, there's a couple definitions that we think are really important for being able to apply these things to marijuana crimes. So obviously, people think about pollution as sort of the Captain Planet bad guy sort of pouring glowing green goo into a waterway, and certainly stuff like that does obviously constitute water pollution. But if you look at this definition, altering a waterway, even in terms of its temperature, in terms of its turbidity, which is essentially the clearness of the water, if you're discharging even solid wastes into a state waterway, that can constitute water pollution. Often, I think we see at some of these sites, as you saw from those photos, things like solid waste or plant material or just refuse from some of these grows ends up in some of these waterways to the point where they affect it. And technically that could constitute water pollution if the right evidence was collected. So not everything is going to necessarily need lab testing or that kind of thing to meet that definition, though certainly there will be situations where to meet that burden in a courtroom, there may be situations where testing would be required to answer that question, especially when things like pesticides are sort of the pollutant at issue. With this definition, I just wanted to point out for not only the definition of waste is fairly broad, but in Oregon, the definition of waters of the state is much more inclusive than the federal definition. So we actually have an opportunity in Oregon to utilize these statutes in a much different way than our federal partners because the definition is much more inclusive than our federal partners. And in terms of that initial water pollution charge, this is a misdemeanor water pollution charge, water pollution in the second degree. All it really constitutes to commit this violation is to violate, and that body of statute essentially refers to the water pollution laws, the water quality laws of Oregon. If you violate a statute under the water pollution laws or a rule, standard, license, permit, or order adopted under those laws, and you do so with criminal negligence, that constitutes a violation of this environmental crime. One thing that's also unique to our environmental misdemeanors is that even though they are misdemeanors, the maximum fine is exempted from the traditional fee structure of misdemeanors in Oregon, and the maximum fine for these misdemeanors is up to $25,000. So that's a tool that prosecutors may find is increases the penalty, so to speak, even though you're using a misdemeanor. It gives another sort of arrow in the quiver for prosecutors if these things are applied to unlawful marijuana grows. Water pollution, the first degree, it is a knowing discharge into the state. It's not with criminal negligence. It's knowingly discharges, places, or cause to be placed any waste into the waters of the state or in a location where the waste is likely to escape or to be carried into waters of the state. And then these two that I bolded here are going to be consistent through all of our environmental felonies. These are the two hooks that get us to felony in 99 times out of 100 in these cases. It's either as a result recklessly causes substantial harm to human health or the environment, or knowingly disregards the law in committing the violation. I'm going to cruise through this fairly quickly. For those who paid attention to HB 4061, essentially the legislature this year has addressed that these two statutes are going to be commonly used by prosecutors in terms of the enforcement of unlawful water appropriation and what we would consider to be quote unquote water theft in Oregon. The outcome for prosecutors of HB 4061, not only to sort of define that it's unlawful to haul water to unlawful cannabis sites, but also that there's a responsibility to provide accurate information to law enforcement. There can be penalties as a result. What it did to those two crimes that I showed earlier, the ORS 537130 and 537535, is that when it's involving unlawful cannabis, that it bumps it up to an A misdemeanor and then adds that $25,000 maximum fine that we see from our other environmental misdemeanors to this. So because we see that this statute is one that would be a lot easier for not only prosecutors to understand, and as we've talked with our water resources partners, it can probably be a lot easier to show that there's an unlawful well or unlawful appropriation of water by partnering with our water resources and the work that our drug teams do. It could be something that could be easily and used by prosecutors, and we know, especially in some of our Southern Oregon partner DA offices, has already been used. So we're encouraged by this change, and it's been we certainly are going to continue to look at how it's been utilized and the outcome of its use. Pesticides. This is something we're still learning a lot about. Essentially, there is a criminal provision of the pesticide control laws that essentially says any violation of the provisions of this chapter is a Class A misdemeanor. There's one particular statute there that outlines a number of prohibited acts, and we see that this is something that, again, when law enforcement and DAs see this happening, it can be something that can be a value added to telling the story of what's really happening on these grows. It opens up the evidentiary portfolio of what's going to be talked about if and when this is actually happening on these sites. But the one thing we've also talked to prosecutors about is sometimes it can be what's actually the violation of these pesticide laws could be something that may or may not help your narrative, while there could be technical violations of it because they didn't read an instruction or something like that. But if there's a difference between someone going to a local Home Depot and buying, something that any one of us could possibly buy, and someone importing a extremely large number of pesticides, even sometimes unlawful pesticides, and using them in these grows. So it's all about, like any prosecution, it's about looking at the facts of what's happening and figuring out what's the best use of your resources in terms of applying any of these. But we wanted to highlight the existence of this to our DA and law enforcement partners. I'm sure the committee has talked about some of the commercial marijuana offenses. One thing that we know has been discussed is adding, more environmental iterations to this, but this is the existing statute. Essentially, to get to that level 8 commercial marijuana offense, you need at least 3 of these. And the ones that I've bolded in this presentation here are the ones that we think currently, as iterated, sort of have an application in the environmental sphere. It's obviously when either public lands are used or if there's significant infrastructure being built on these sites to create a more enforced or a larger scale operation. We think that there's room for environmental additions here, but that's obviously for, we work hard to identify how we use the tools that we have currently and how we can best use those. That's been our focus this year. But as we talk with our county partners, this is something that's come up a number of times, is this particular statute. My presentation is frozen. There we go. Okay. Hazardous waste crimes, super fast. It's BHO labs, butane hash oil, for those who don't know, and other cannabinoid concentrate processes when they're happening unlawfully, where we think that this could happen. We're still looking at sort of what the scale of this issue could be. The big question here is going to be, first, is whatever's happening actually hazardous waste? It's a complicated question. The federal RCRA statute is going to play a role in that question, and it's certainly going to take, most prosecutors are likely not going to have significant experience with this statute, and it's going to be something that's going to require coordination with your partners who do know that. But it is unlawful to unlawfully treat, dispose, or store hazardous waste, and it's unlawful to transport it. And those same factors that we identified to you that make felonies are the things that can bring that to a felonious level in Oregon. We do think that these things are happening, but we are still learning a lot about sort of what the reality of what these crimes may be in Oregon as they come out. And it is a case-by-case basis, obviously. Just a quick example, though, like BHO explosions are something that communities deal with. This is an example of a case from Southern Oregon where a firefighter was injured after a forest fire was started as a result of a BHO lab explosion. We can't say for certain whether or not this was an opportunity where these charges could have been used. We don't, I think, know necessarily some of the chemicals that were used, but it's something that as we talk to our partners, we know that this is something that obviously these are volatile chemicals that can cause harm to human beings, that obviously can cause sort of dramatic outcomes when used inappropriately. And we want to make sure that we are encompassing every variable we can. That's been our goal, is to really look at this type of question so that situations like this can be prosecuted successfully. But we do know that the Jackson County District Attorney's Office got a great outcome here in terms of a prosecution for cannabinoid arson, essentially. And finally, this is just our big, if we talk about this situation where human life could be hurt as a result of an environmental crime, this is our most serious environmental crime in Oregon. We just wanted to present it to the group. It does not obviously come up very often, but the penalties are extremely severe when it does. But essentially what it is that you commit a separate environmental felony, and then as a result of that environmental felony, you place another person in imminent danger of death or cause a serious physical injury. Again, there is the outside chance that a cannabinoid or a cannabis type operation could find themselves in this situation, but obviously we hope, like anything, that this is not something that happens hopefully ever, but as rarely as humanly possible. There's a lot to the Environmental Crimes Act that we didn't talk about today. If there's other questions, please let us know. But as a whole, that's what we've identified as being the most likely portfolio of crimes that we think our county prosecutors and our county law enforcement, or our local law enforcement agencies, are going to see when these situations arise. And what we've been doing is working hard to educate, to see if these tools work, and if they don't, what the issues are. And we're still definitely doing a lot of work in that department. We've been so thankful for the partnerships that we've built, and we want to continue to build more relationships and keep having these conversations so we can better answer for groups like this subcommittee on how this situation could be handled better and just make Oregon safer as a result. So if there's questions, I know we've come up right on 45 minutes pretty much. We are also available to talk after the fact. If someone has specific questions that they'd like to give to us, we can certainly make ourselves available. We are very appreciative for the time here today. We'll continue to work on these areas, and we welcome any and all feedback and direction in terms of who and what we can talk about in terms of asking these questions.
Thank you so much, Jordan and Patrick. Are there any questions or comments from task force members about Jordan and Patrick's presentation here about environmental crimes? And thank you for finishing up in your 45-minute allotted time, almost precisely.
Thank you very much, everyone. And if questions come up later, please don't hesitate to reach out to us.
I've already sent you an email, so yes.
Thank you, Rob.
Thank you so much. All right. Well, I don't see any hands raised from task force members, so I'll move on to our next agenda item, which is actually seizure reporting. I think Ryan Keck might be available. Oh my gosh, Ryan, there you are. You're probably sick of seeing me in public meetings, but here we go. Ryan Keck will be presenting us some information about seizure reporting. So take it away, Ryan.
Right. Thanks, sir. Good morning, everybody. A moment while I share my screen. What are we doing in terms of a screen share? Can you see slide deck? Okay.
Yes.
Excellent. So again, good morning. My name is Ryan Keck. I'm the programs director here at the Criminal Justice Commission. Our director, Ken Sanchagin, was unable to make today's meeting, so he asked me to fill in and provide you all with an update related to the illegal marijuana enforcement grant, and particularly the reporting requirements. So moving forward, as just a source of background for, I think probably all of you who know this, but just to remind, we have gone through the grant making process for both the initial 2021 award cycle as well as in the one-time funding that was added in the 2022 session. Grant making went out or was conducted. We had a total of 12 awards, 10 of which were law enforcement agencies, and you can see a summary here. I raised this also just to remind everybody that the breadth of the state of which has been, was further taken in by the grant making process this year. Being the acute issue in Southern Oregon, we have more Southern Oregon counties specifically receiving funding, as well as other counties where this problem is also in existence and additional assistance was needed. I also want to point out as we transition, of course, we have now legislative reporting responsibilities that came along with these grant programs, which is where we've been focusing our efforts and energy. In January of the coming year, we have 2 reports now due, one which focuses in on funding recommendations and as it relates to the grant, as well as then a continued evaluation of outcomes and impacts of the program. And so it's on that point, I guess I want to raise that where we're shifting our focus. Now, the grant making has concluded, at least for this cycle. It's our goal is to weigh in and participate in the collective statewide efforts to better understand the scope of the illegal cannabis problem, as well as its impacts and the resources that are needed to address it. And so we've taken to doing that by way of how we receive better information or different information from our grantees. So we spent some time revising our reporting criteria for our law enforcement agencies, and then have created reporting criteria for our community-based organization grantees that have been added. With law enforcement, we've traditionally asked for information related to arrests, convictions, as well as assets seized, but have recognized that we've asked a limited amount of information as it relates to the point of seizure reporting. We've asked for lists of items and case numbers, and that's been the extent. One thing we've learned over the years in trying to reconcile specifically the illegal marijuana grant with, say, larger statewide asset forfeiture reporting is that we need to ask for more information and better understand where or in which ways it's reported, seizures are reported, or forfeiture is, because of the collaborative nature in which enforcement typically occurs. And so in the new reporting requirements for law enforcement agencies, we're asking questions in relation to the agency responsible for that reporting, as well as then case numbers or other information. Our goal is to have that be a focal point of conversation with the grantees and be able to then broaden, or I should say not broaden, but narrow down our focus and able to understand where and how seizures are processed in any given jurisdiction. One of the ways that'll help us do that is that the new reporting requirements are tabulated by incident. So grantees are now reporting, instead of collectively for a 3-month period of time, just the number of seizures made or the number of arrests made, etc. We're looking to have it kind of bisected by incident. And you can see on the slide here, although I apologize, it is small, the way in which they've done that. So our agency will report kind of based on an incident and a date. They'll work through a series of reporting criteria that includes other additions like incident location information, so we can understand where some of the repeat and or hotspots might exist within a jurisdiction. Again, this forfeiture case responsibility information we've added to under the increase or the increase or the expanded focus of the grant program as it relates to some of these larger issues and impacts of illegal marijuana grows. We're asking for information about human trafficking, as well as environmental issues that are encountered, where the collaboration existed then between law enforcement's actions and other regulatory or service providers. And then a number of questions that get specific about the resources utilized for that particular incident as a way to better evaluate. With the community-based organizations, the grantee reporting is similar but different. It is focused in on more of a, trying to narrow things down so for the sake of analysis, but we do ask for a number of data points as it relates to referral sources and services provided at an individual level. All this information, of course, will be requested as in a de-identified manner to protect confidentiality, but some demographic information as well is requested of these organizations, as well as the efforts that they may be making to do outreach within their communities and educate on both the services they have available and ways in which to help prevent and or report illegal marijuana and or its related impacts. The last piece I wanted to relay was in the efforts we're continuing to make, again, to contribute to this larger statewide effort on the topic. And so we worked with both the grantees, but also partner agencies in the development of this reporting. And our goal is to continue those conversations as well as look at ways in which to share data. We've engaged with a number of the state agencies, engaged with both this task force and on this issue abroad in what they're already collecting in hopes of just kind of sharing, not creating more work for anyone, but bringing that information together so that each of us, as we make our individual contributions towards statewide efforts, we're informed by what's going on in our partner agencies. So you can see a list here that of a number of state agencies invited to, and we've been engaged with. We have one in particular, a discussion on this topic tomorrow morning with a number of agencies that have been invited to further this conversation. I will, I guess, circle the last piece that's not really on the slide, but just add to, and I know because the interest was on seizure reporting, is to say that what's not included on the slide is also our plan to do periodic check-ins with the counties in addition to just receiving their data. But our goal is to be far more communicative in our grant reporting process. So it's not just receiving the data and reconciling it for data cleaning, but also to talk about changes in process, efforts towards achieving outcomes so that we can better understand the way in which any local entity and or per incident, if need be, the assets were processed and where in which way it's moving forward through the procedure. So that's the short and sweet update that I have for you as it relates to reporting and or forfeiture, but certainly open to any questions you might have.
Great, thank you, Ryan. Any questions or comments for Ryan from task force members? Not seeing any. Thank you so much, Ryan, for the information. We'll be talking about this again here probably pretty soon. All
Thank you.
right. Next, I guess I'm up, at least to lead the conversation here as the scrivener of our latest draft legislation. Just a reminder, the full task force meets tomorrow, and each of the 4 subcommittees will be bringing their at least initial recommendations to the task force. So this particular item has the potential to be our recommendation, depending upon what subcommittee members want to do. This is just an initial recommendation for the task force, just intended to kind of broadly cover what we've been working on. So there'll be, lots of opportunities for changes, public testimony, assuming any of this even goes forward at the task force itself, plus obviously public hearings in front of the legislature as well. I'll just note that I'll kind of walk you through the 6th draft. I won't spend a lot of time on it because we've talked about this quite extensively. I'll really mostly focus in on the changes we've seen since the 4th draft, and then I'll let you know about some additional potential changes that have been suggested. So just by way of a summary, just to catch everybody up, it still has largely the same 4 sections, 4 chunks of sections that we've been talking about. The first relates to cleaning up our search warrant statutes. I did receive, as anticipated, some input from the Oregon Judicial Department about those. Senator Przonski also mentioned some of those changes that OJD was looking at. I've incorporated all of those into the 6th draft. And I think I warned everybody that my initial draft, everybody was going to dislike anyways. And sure enough, it caused people to say, hey, you can't do it that way. So we've tuned up all of those things. Hopefully sections 1 and 2 read well to folks with OJD's changes. The second big category is the law enforcement tools. We didn't talk much about this last time because I think we'd pretty much hammered out how all those law enforcement tools can work. We're basically adding back marijuana into the provisions that got removed some years ago. There was actually a bill to fix that, but the legislative session crashed, and so that bill didn't pass. So this is largely carrying forward those. The biggest change probably between the 6th and the 4th draft, well, not probably, it is. The biggest change are the enhanced criminal penalty provisions. As I told everybody, what I crafted up previously was just a conceptual kind of placeholder to talk about the enhancements for environmental crimes, for labor trafficking, all of the stuff that we've seen described here by both Sheriff Sickler and the presenters over the last couple of sessions. So these changes really incorporate all of the recommendations made by the Oregon Department of Justice. They let us know they were going to make some suggestions, and they have. I read through all of those and plugged those in to the draft, so you'll see essentially how those those enhancements work at either a level 6 or a level 8, depending upon how grave the environmental and/or labor trafficking offenses are. So that's the 3rd big section. The 4th big section is actually just the cleanup and lien provisions that I kind of borrowed out of the old meth lab statutes. I believe that there have been concerns expressed about the details of that language by, I think Tyler expressed some and DOJ expressed some. We have plenty of time to tweak those. So it's just, we're still leaving that as an outline. I didn't receive any comments back from anybody on those provisions, but I'm the first to admit that they could probably use some additional eyes and probably some work as well. I can let you know, I did speak with Senator Przonski this morning, and he's in favor of moving the draft 6 forward as our placeholder to the full task force. But before we get there, let's talk about these sections. I know that Kaity's here from Oregon Judicial Department. She has provided me some additional tweaks. I won't bore you with any of the typographical things. I'll fix that for everybody. But why don't we open it up to Kaiti at least, and then anyone else who wants to have any comments from the task force on the 6th draft before we kind of take it up and potentially vote on it. So why don't I turn it over to Heidi first, and she can go through her potential tweaks, and then we'll go from there.
Thanks, Rob. And also thank you again, Rob. I'm sure everyone is thinking in a way. Oh, I see that there's a hand.
Do you want to go? Do you want to go now, Tyler? Or do you want to just wait till Heidi? I'll put you up next. Tyler's next in the queue.
Okay, well, first off, thank you so much, Rob, for all of your tremendous work. I'm sure everyone's feeling a little bit of a sigh of relief that you have taken the rowing oar on drafting. And so these comments are really just kind of some observations from OJD. They're not intended to be an indicator of a particular opposition to the concept or anything along that line. It's really just observations, comments, and I defer to the subcommittee in terms of how to evaluate these. Primarily the areas that, at least on my team, that we kind of noted, and I thought I'd elevate upwards, would be starting on page 13 of 19 in the draft, which is, section 10, subsection 5, just to give everyone a little bit of anchor points here. And this was there's just a couple of just small things. Again, Rob, you've done a great job of reiterating, like, this is a draft, there's a lot of room. But some of the things that we would just note are, for example, in subsection 5, on page 13 at the bottom, I'm just going to kind of highlight this. Between page 13 and page 14, there looks to be 2 little i's. And so that might shift the reading of the concept itself. And so with that caveat in mind, when I look at the first little I, which is the violation is accompanied by any of the following facts related to any person engaging in services, that statement, and again, given that there's 2 little i's, it might shift. Just kind of wanted to throw it out there that maybe some intent on what these services might be. But again, if drafting shifts how that is framed, totally fair. So that's just kind of a flag. The other one that I wanted to flag was the abusing or threatening to abuse the law or legal process language. And this is just one in which I would just offer that, if there's contemplation or interest in providing maybe more definitional language or something along that line, that might be helpful just to kind of contextualize what that's including, just because that could be an area that's ripe for ambiguity depending on who you are and how you read it. The other one that I thought I'd flag is the passport or the purported government identification. And again, this is all just up for the subcommittee. These are just some observations. Would it be perhaps more clear, or is it even contemplated in the subcommittee that it's really relating to the documents of another person and without their consent? So again, this is a little ticky-tacky. Thank you everyone for your patience. And then the other one is a quick flag on the violation is accompanied by a violation of ORS 654.071. And my read of that, of ORS 654.017, isn't actually describing violations necessarily, rather it authorizes the issuance of a citation for a violation. And so I think if there wants to be some thought in terms of crafting to make sure you're capturing what you're wanting to capture, that might be an area. And then lastly, here, wrapping it up, I apologize, Sergeant Bechtel, for taking over so much time here, is the discharging or placing or causing to be placed in any waste into the waters of the state or in locations. This is one where I think it just, it's a question of whether or not the intent of this committee is to pertain to unlawful conduct, or if it's to be more broad than limited to unlawful conduct. And so that was just a question I thought I'd pose. And again, these are just comments, observations. This is not intended to be a position or an indicator from OJD. Just want to be a helpful contributor. So thank you.
And I appreciate it. Now, you don't have to caveat it anymore. I'm not the greatest drafter in the world. And 3 of these 5 are clearly, I just messed up in writing. So I'll fix those, no problem. A couple of them are pretty substantive though, and we'll see what folks think. Looks like we have Courtney with a question or a comment. Go ahead, Courtney.
Did Tyler want to go first?
Yeah, he may. My question of you is your comment on something that Kaidi said, or would it be just generally?
General over the whole draft.
I'll put you in line right after Tyler then. Okay, go ahead,
Okay,
Tyler.
great.
Well, I don't want to jump ahead of everyone. If there's more discussion on what Kaidi shared, I think I'd like to hear that. If anyone's got anything.
Anybody have any comments or questions about what Kaidi's mentioned? I think all 5 points are pretty valid. 2 of them I got to look at some more. 3 of them I'll just fix because they're just errors. All right, not seeing anything. I think you're up, Tyler.
Okay, I am working on a little laptop out of my office, so I'm going to try to switch back and forth between the Teams meeting and the document. Section 9, line 16, it talks about 100 mature and immature plants, and I'm just wondering, I guess more of a question than anything else. Are we looking at 100 immature and 100 mature plants as far as moving it up to the level 6, I believe is what it was, or is it mature or immature plants? And I guess I just want a little more clarification there.
That's a darn good question. And since I got this, I think I got this primarily from DOJ, I can only kind of guess, but that is a legit question. It probably should be an or, but maybe not. Committee members have any thoughts about that? This would create, this enhancement when we're at essentially trying to create an upper level crime when we aren't just having a few more plants than you're supposed to have, but literally 100 or above. So looks like Sheriff Sickler might have an idea about what he thinks on that. At least I'm seeing him flash on.
Well, I'm just, I'm curious about if that is necessary, and this is where Sergeant Bechtel might be a better resource. But early on in the season, when we go out and we get reports of growth starting or whatnot, and they have thousands of immature plants, so to speak, and no permitting. I mean, to me, that's just a precursor for what's to come. And so I don't know if we want to include 100 total or 100 and 100, but I think either way, I mean, I think if you have 100 immature plants, I think we know what the plan is, right? If you don't have any permitting whatsoever. So I'm thinking of either or, combination thereof, so to speak. But I don't know. The ground troops might have a better sense of that.
So I can say that if you strictly read this in October when I come out and there's 10,000 flowering plants, we don't have 100 immature plants on site. So I don't know that this would apply. And if I was a defense attorney, I'd certainly argue that it wouldn't because there wasn't any immature plants there. So I think total cannabis plants is probably the way to go. And how that's written, I think is pretty irrelevant.
For me, who cares about how things read in 475C, the way I would craft that, it would be the violation involves the manufacture of more than 100 marijuana plants, whether mature or immature. So you just total them up.
So that brings up another question. Now that we're using these light lab machines, we could probably tell the difference between a marijuana and a hemp plant. But it does raise the question of I don't know, we haven't seen it yet, but are we gonna find 10,000 plant illicit hemp operations, and by statute it's 4 plants? I doubt it because there's not a lot of money in the game, but there might be a future where there is. And then so that's just a comment on that. And then I've got more for the the sections, I believe 11 through 15, the lean and clean up if we're ready to move on to that.
Let's see if we have any more comments on that tweak to line 16, 17 on page 12, which is at the bottom of section 9. Are folks feeling all right about the changing the language to how I described it? It's essentially you're just counting plants, perspective of what they are. Okay, I'm seeing a lot of nods. Oh, Josh got something. Go ahead, Josh.
So this is sort of out of my role normally because I'm, prosecutor, but did we pick 100? Because that's pretty low bar, at least. Like if we're trying to encapsulate the egregiousness, I mean, I haven't seen one that's under 100 yet. Like we don't have time for less than thousands. So, I mean, I don't know. I think
it's just a number that got plugged in. So that's flexible along with everything else.
I'm not advocating to make it less serious. I'm just wondering because in practice, that's going to end up being everyone, at least where I am and my neighbors, I think.
Josh, that's such a good point, and really kind of, I think it would hammer people because it is not unusual to have 25 plants and 100 clones to get to those 25 plants. So if any of my teams went out to a grow with only 100 teams or 100 plants, I would be kind of upset. I would call that a waste of a day. 1,000 would be much more realistic.
Well, maybe we should. I mean, because we had it as 100 mature and immature. I get the idea where depending on what season toward the season, that doesn't make any sense. Maybe it should be a bigger number. Maybe it should just be a flat, straight number like 200 or 250 or whatever it is. Because it doesn't sound like you guys are going to be prosecuting.
Should it be tiered, Rob? Because neighbors to 100 plants aren't happy with 100 plants either.
That's
And
true.
when you're only lawfully able to grow 4 plants without a license, 100 is a lot compared to 4. And then you have 1,000, then it's like a mega growth. So I mean, we talked about having a tiered approach. And maybe that's the outcome is, but when you combine impacts on the neighbors, on the water sources, on all the other stuff like that, I think we might need to consider, I don't know, maybe tier it.
Yeah,
we have this one tier, but I could certainly add a second one. I could create 100 and then or 200, and we could do something else as well. Anybody have any thoughts?
Well, my fear is I don't know that we should make rules. I even know it's easier to accept some level of illegal activity, right? Like we move this sliding scale to I think we also always have enforcement priorities, and we also have prosecutorial, priorities. And I can say that we're not interested in 20 plant grows either. But I fear that if we set the limit too high, like say 500, we're going to have 499 plant grows everywhere. If we set it at 1,000, we'll have 999 plants because people are smart. And so I think, the messaging isn't go hammer somebody that's, at 100 grows and spend all or 100 plant grows. But eventually we could come to that, maybe in 10 years, if we continue this enforcement effort, there may not be those many. I don't know. I just feel like we shouldn't set it to a point where we're regretting that we wish we would have done something different and go back and try to change it again later. And I can attest that we have way too many grows to mess with these little things. But at some point, there may come a day when that's feasible. And I'm not saying any people need to get in prison for it, but I don't think we should accept the illegal activity either.
Well, how about we create the tiered approach that Representative Morgan suggests? We enhance it to a felony level at 100, but we don't subject it to, the higher level 6 or 8 grade until we get to whatever the next number is, 200, 250, whatever that happens to be. Maybe that's a logical way to go.
So it's currently a felony for more than 12.
Right.
Yeah.
So my thoughts had been a tiered similar to like 475, 900 or wherever, where all the other drugs have 550, 100, 10, 100,000 kind of.
Well, I just saw Kurt Miller raise his hand, and so from DOJ, since I think if I recall correctly, I got this from him. Kurt, do you have any thoughts?
Yeah, and sorry I had to jump off earlier for another call, so kind of missed some of the comments. So please tell me if I'm reiterating things that have already been discussed. But the way I'm reading how it's kind of worked into there, Rob, is that it's only a level 4, even if it is 100 plants. So
Right.
When we're talking about level 6s and 8s, that's only if it's 100 plants plus the environmental factors plus that. So
Right.
don't we want that to be an increase with those, despite the fact that it's 100 plants or 1,000 plants, right? When we're talking about the environmental impacts and the human trafficking issues. So I thought that was kind of the severity of the issue, not exactly the plants.
I think that was kind of the intent, at least what I
And that's a
heard
good
from
reminder.
folks. Yeah, so I mean, and I guess it is tiered in that way. If people are doing the severe environmental crimes or the labor trafficking crimes, that's where you really get to prison at a 6 or 8 potentially. Whereas you're right, Kurt, at 100 it just kicks it to that next level of 4. So are folks fine keeping it 100? I know Tyler will be mad at his crew if they go after anybody like that because they don't have time for. I know it seems like that shouldn't be a small grow, but in today's world, that's a small grow. What do you think, Sheriff?
Yeah,
I think it's reasonable. I mean, at some point, things will adapt and change, and we may have to make adjustments. I mean, we've seen low plant counts, but the plants were so big. There's like the size of Volkswagens, and they're producing a tremendous amount of product. So I think things will just evolve and things will change, and we'll have to adapt. But I think the whole point of this legislation is to say that somebody who grows 13 plants isn't subject to the same penalties as somebody who has 100 hoop houses on the side of a hill and carved out trees and diverted water and did all these things. And that's the goal, right? I think that's to provide a deterrent that makes sense for these large operations that have such negative impacts.
Well, how about we do this? I'll fix the language to make the math easier. We'll keep the number in the draft, and then we'll just talk to the full task force about this issue and just flag them to the fact that we may need some adjustments. Heck, the legislature might very well adjust it to a different number at some point in time. Does that sound all right to everybody? All right. All right. Before we get to Tyler's sections 11 to 15, I'm anxious to hear about all that because I'm happy to tweak all of that. But let's get to Courtney because she had something else I think to add on the other sections we were talking about. So go ahead, Courtney.
Yeah, thank you so much. So I have 3 different comments here. One is just, generally framing what we're doing with this recommendation. And, I mean, we're a law enforcement subcommittee in the broader House Bill 3000, Senate Bill 1564 task force, right? And we're working on illegal marijuana or illegal cannabis production issues. And so when I'm looking at section 1, I'm happy to see this new and updated definition of interrelated conduct. But a concern that's been expressed to me by the broader cannabis community, but also by criminal defense attorneys, is that the modifications that we're proposing to make here is to broader search warrant authorization and authority. This hasn't been limited to interrelated conduct of cannabis crimes. And so is it really our role as a task force to be broadening out general search warrant authority across the board for any crimes? Or should this be limited and related to interrelated conduct between cannabis crimes and other crimes in different jurisdictions? That's my first question, comment, and I'm curious what the rest of the subcommittee has to say.
And that is a correct statement. Sections 1 and 2 aren't strictly confined to cannabis because we're tuning up the statutes related to search warrants in general pursuant to our discussions and OJD's recommendations. I can certainly craft it to be confined to cannabis crimes only. Thoughts from others on that particular issue?
I have one, but I can't find the hand button.
Go ahead, Representative.
What comes to mind is recently a search warrant, there was a press release that came out. Search warrant was served. They saw illegal activity on a neighboring property, requested a search warrant, and then by the time they entered the property, the plants had all been harvested. So then, I mean, there's more to it and all that other kind of stuff, but there's always time frame. And can you have the human trafficking element, the water theft element, the pollution element, all the other things that are related to cannabis, but maybe the plants were pulled? Is it still related to cannabis? I guess I'm just trying to, and what happens when there's also firearms and there's also some other element of, I mean, the drug trafficking organizations don't always just limit to cannabis. We recently had one where it started with an animal investigation and resulted in finding a illegal grow and dead animals. And so then I guess I'm just trying to figure out if there's the impetus of you have one judge issuing a warrant with the blessing of the presiding judge of the neighboring county, if something that is a related crime in both areas, I don't see that it's an issue.
Anyone else? Thoughts? My own thoughts are, I tend to agree with Representative Morgan. Drug trafficking organizations don't confine themselves to just cannabis. I can actually see where we would use this statute to get at fentanyl and meth, because the DTOs are working up and down the Willamette Valley and, well, throughout the whole state. So I guess my take is, I think this is good policy generally, but that's just my take.
Rob,
Looks
it's
like we
Floyd.
got
Can you put me in
Tyler
the queue?
go ahead. We got Tyler and Jake.
And did you hear Senator Brzezinski as well?
Oh, Senator Brzezinski. Well, he's the chair, so take.
No, just put me in the queue.
Okay, so we got Tyler, Jake, Sheriff Sickler, and Senator Brzezinski. So Tyler, go ahead.
Yeah, so I just wanted to speak to Courtney's points, and I think I kind of proposed this, so maybe I'm best to address it. We can already get warrants, in one county for multiple counties. We just show that evidence related to that crime prosecutable in the county that we're applying for the warrant in will exist at that other location outside of their jurisdiction. And we really haven't had problems doing that. I think I wanted clarification mostly for district attorneys and mostly related to our issues that we have with prosecution in multiple jurisdictions. And this is kind of the way that the committee went. I think it would show prosecutors that this is a priority to get this multiple county prosecutions in one spot. But other than that, it doesn't really address what I need, and that is for a prosecutor to say, yeah, I'll take that all, and we'll charge that as the racketeering or the conspiracy. And that's really what we need, because we can articulate this to get the warrants out of county. We do it all the time. Other teams do it all the time. It's a little extra work, but it's not work that we're unwilling to do.
Can I just ask Tyler a question? So you already can basically do this of what's in here? Is that what you're saying?
Yeah, absolutely. Absolutely. We do it quite frequently. Everyone seems to live in the Portland metro area, although they'll own rural properties through Yamhill, Polk, Lynn, Marion, Clackamas counties. So we'll want to get back to their house for their purchase records, their banking records, their cultivation records, and all of that stuff. And we have very little issue doing that. Where we get into a problem is, let's say we're investigating I'm just going to pick a county, a Lynn County grow, and the people that control that grow are in Multnomah County. And we go in there, and then we find that they're also growing in Multnomah County, or that their conspirators are also growing in another county. We end up with the same affidavit in the same case, being prosecuted maybe in 2 counties, but the third just isn't interested in it. Or we just end up with this situation where we've got an affidavit in one county and we're trying to prosecute a crime in another county. It gets really frustrating. You know, a defense can take a motion to controvert, and if we applied, I guess, in Multnomah and Clackamas with the same affidavit, then we have, you know, twice the legal proceedings to attend for the same case, for the same conspiracy.
So would this not require you to be having prosecution in the multiple counties, or you would still have to?
I guess what I'm saying is this change doesn't really address the problem I brought forward, which was getting prosecution for the conspiracy or the racketeering activity in one county. It definitely, I believe, establishes for prosecutors that this is a priority for this committee, and it's a priority going forward that we make it easier to address this multiple county illicit operation in one place at one time.
Well, and along with that, I think one of the other concerns expressed was, is there going to be jurisdictional shopping from a law enforcement perspective? You know, if they know that one county will not prosecute, but another county will, are they going to pursue the search warrant in that county that they know will be more likely to actually prosecute versus the county that's unlikely to prosecute, even if there is interrelated conduct?
I'll be frank. Yes, absolutely. Okay. We will go where we get the most support from prosecutors, because our job, of course, is to put cases together for prosecution. So yeah, absolutely, we would go to where we get the most support.
Okay, thank you for being honest about that. I mean, I would expect there to be lobbying opposition to this if this goes forward, just to be clear.
Yeah, but in all cases, you're going to go where the bulk of your criminality is occurring. In that example I brought up earlier, where, you know, maybe the plant's in a rural community, and then the house with the documents and maybe the money and the money laundering activity is in another county, you're probably not going to try to prosecute everything in the county where the records are, you know, because the underlying activity or the specified unlawful activity that took you to that house in Multnomah County is in that rural county. So everything is probably going to be prosecuted in that rural county as it is. But say we have a crime that's half occurring in one county, half occurring in the other county. One county is overworked and underpaid. One county is aggressive. Law enforcement would be silly not to go to that aggressive county.
Thank you, Tyler.
All right, next in the queue is Jake.
Can you hear me all right? Awesome. Yeah, I had to call in, so I'm one of the unidentified phone numbers down there. Jake, Water Resource Department. I just wanted to clarify, I don't have the most recent draft in front of me. I apologize for that. But are one of the chunks here that we're taking a look at, I hear the multi-jurisdictional warrant process, but is it also rounding out, including more authorities to be able to be present, including that little subsection about state employees and state enforcement agencies?
That section does include that, but we haven't gotten any comments on that. We talked about that extensively. Okay. That may be one of Courtney's other 3 that she's going to talk about, but we haven't gotten there yet.
Okay, well, I will lower my hand until that comes up if it does, and yield to Senator Brzezinski or Sheriff Stickler.
All right, Sheriff Sickler's up next. After that, Senator Brzezinski, and I see Kurt Miller has raised his hand after that.
Yeah, I think Tyler covered most of. I think I would agree with what he said. To answer Courtney's question is, I think when we first talked about this, just to go back and refresh, is we had some jurisdictions that were not interested in potentially even prosecuting or issuing warrants. And part of the conversation is just because a district attorney's resources don't allow or their beliefs don't want to, shouldn't impede law enforcement from doing their job, or just because judges don't believe something should occur and not sign a search warrant or whatever in a particular jurisdiction, doesn't mean that law enforcement should investigate, or it shouldn't preclude law enforcement from investigating. So I think that this adjustment will fix that, because it provides some checks and balances to that type of system per se. And to Courtney, I would say this: if people are worried about aggressive prosecution in counties and other counties and shopping, tell them not to grow illegally, and then tell them not to grow in multiple counties, and that will fix that. Go to a county that doesn't want to prosecute and grow the illegal marijuana there. And not to be flippant about it, but seriously, it does present challenges when these organizations operate all over the state, and they do this purposely because of the inconsistencies and the difficulties with the criminal justice system to make cases and put them together, I believe. So I think this does help, and I do feel that it will provide the ability for the checks and balances that may be needed to have, I guess, equitable prosecution and enforcement in all parts of the state.
So can I just make a comment, Sheriff? And with what Rep. Morgan said, I mean, would it make more sense that this would be tied to controlled substances crimes? I mean, it doesn't have to be cannabis per se, but substance crimes versus just crimes across the board.
Yeah, I thought about that, because we're talking primarily about DTOs or cartel or other things, but then it's interesting. Oftentimes, not always, but often we find we service search warrants on something related to drugs, and it does spear into something else. There's other evidence found, and then those crimes do need to be investigated potentially, and it does create the need to write additional search warrants if you're looking for new evidence based on what was found at your original search location. So my thought would be is if you hamstring it too much and create that there has to be a nexus to a certain thing, it will probably open the door, and I'll probably have to defer to the DA here, Eastman, about how attacks could be made more frequently and tie up resources with legal challenges to prove these nexuses and all these things. I don't know. I'm just kind of spitballing from experience, but I think if the law is too narrow, I think the challenges will come more so and convolute things even more. But I don't know.
So I've got Kurt Miller up next, and then we'll go to Courtney's second one. But before we do that, I just have a comment just to remind folks: confining it to controlled substances won't actually work, because marijuana has been pulled out of the State Controlled Substances Act. Further, I mean, we've been talking a lot about labor trafficking. If we confine it to controlled substances and cannabis, that wouldn't cover labor trafficking. So I don't know. I tend to agree with the sheriff. If we try to confine it, I think we're going to create unintended consequences. I understand people might fight this and argue against it, but it doesn't make sense to me to confine it. But that's just my take. Kurt, you want to take a stab at this?
Sure, but I do know that Senator Brzezinski was also on the queue, and I didn't want to cut him out if he wanted to go first. Oh, that's right.
Senator Brzezinski. Go ahead, Senator. Sorry. You're the chair of the subcommittee.
No problem. Thank you, Robin. Thanks, everyone, for being here. I'm in transit, and that's why I'm not there. That may have been said earlier. But I have been picking up on a little bit, and this last portion, I just felt like I wanted to put something, interject. And it's kind of what Rob was saying. First of all, cannabis is no longer a controlled substance. I was thinking as a way to, let's say, get a mediation that maybe we look at cannabis and for controlled substances. If we do something like that, then as Rob just said, we have to have maybe some type of, I am going to call them carve outs or some type of exceptions where you do have these other issues such as labor, trafficking and stuff like that. So I just think that, I hear what Courtney's saying. Now, don't disagree, because I think we are going to, once we get into the legislative portion of this, and the session, we're going to have a lot more people coming to the table. They're going to have a lot more interest and potential concerns if we just open this up across the board for any and all search warrants. So we just need to be cautious about that. The last thing I'm going to, unfortunately, kind of, I hate to say gunny sack, but go back to something I heard, which I pondered, and since I got on for this comment, I just want to say on the number of plants, I understand that we're probably going to stay at 100. What I didn't hear was whether that was going to be mature, immature, or a combination thereof. My suggestion is that, based on what I've heard, maybe we do demark that as mature versus immature, so we don't get into this really smaller areas that we've already heard from law enforcement would be hard pressed to put the resources in. Those are my comments. Thank you.
Thanks, Senator. I think Kurt's up next.
Thank you, Rob. So I just had a couple of comments, and while I appreciate law enforcement, both Sheriff Sickler and Sergeant Bechtel's comments on it. And I completely recognize that with the concept of venue shopping, it doesn't change legally, it doesn't change our venue statutes, right? So if Jackson County has absolutely no tie to file a case, the DA in Jackson County can't file a case, even if a warrant was served in their particular county. And so I don't want to get aside with this issue, because I don't appreciate venue shopping, but each individually elected DA in each individual county is the best determination of whether or not something meets the ties of their county. And let's not forget, this isn't an expansion on law enforcement's powers. This is actually an expansion on the judge's powers. And it's the judge who is able to review and make the best determination of whether or not something that happens in another county is interrelated with their own particular county, and whether or not their own particular county would meet the definition of venue that's in separate statutes. So I think this is not like really kind of playing on law enforcement's ability to go around and find things. It's just having a judge make an initial determination of a venue issue, and whether or not it still has a tie to their particular county. Yes, it could be wholly in another county, but it still relates to an incident in their own county that could show the RICO issue or some other DTO, drug trafficking organization issue, as the Sheriff pointed out. And to limit it to only cannabis just seems logically inconsistent, right? We're talking about the bigger picture here of these organizations are most of the times not only into cannabis, but controlled substances. What's now going to be mushrooms, right? Which is, or psilocybin, which is yet another pulled out subsection, interrelation with weapons, sex trafficking, labor trafficking. And so I don't think we could write a statute that hit all of the issues we had without basically including all of the other crimes as well. So that's my legal piece of it. And I completely understand what Senator Berzonsky said. This is really going to be a policy issue for the legislature to decide what the judges should have the ability to do within their own county, since we all know that anyone, if they really want to just shop this, they can just go to the Court of Appeals of the Supreme Court, which has the authority to issue warrants in any county within the state. So that's my 2 cents, and unless anybody has any questions.
Thanks, Kurt. Great summation. Courtney, your hand's still up. I think you had 3 more to talk about.
Just 2 more. So the other recommendation that was made to me was that we should, and this is like 6, 7, 8, 9, or I think 7, 8, 9, on the increased penalties, that we should be looking at possession differently than manufacturing, and so that they're all being proposed to be increased to Class B felonies. That maybe we should look at a delineation between an increased penalty for manufacturing different than the increased penalty for possession. I don't know exactly what those could or should be, but that was a concern expressed to me. And then the other
Go ahead.
Well, did you have a comment?
No, I just I'm still processing. I'm not sure what to do with that. So
okay. And then the other comment that was given to me is in section 10, looking at penalty factors in subsection 3B, the offender is in possession of more than $300 in cash. I don't think it's uncommon for a lot of people to have $300 in their wallet. So perhaps we can look at a higher figure. I mean, someone recommended to me $100,000. I don't know if we want to go that high, but I don't think $300 is really, I don't know, something that we should be concerned about somebody having in their wallet.
So and just in my own, I guess, defense as the scrivener, I didn't really try to adjust in this particular draft any of the historic commercial drug offense language. And certainly we can tackle that. I was just trying to be surgical and add just the enhancements that we're dealing with on this task force. But I hear you. I've worked with others that you know and I know on trying to adjust those over the years, and we've come up with various plans, but we've had 2 crashed legislative sessions, and so we couldn't really address that. But I get your point, and some of this stuff is just historic. I mean, it's just been that way forever. For example, the $300 is probably written when $300 was probably worth a lot more than $300 is worth today. But I don't know if the task force wants to get into a bigger conversation about the commercial drug offense statute. Anyways, it looks like we have another hand up, or is that still Courtney? Does anybody have any comments or questions about either of the 2 items that Courtney raised, which is addressing possession versus manufacture differently, and or dealing with other aspects of the commercial drug offense statute?
I had a question for Courtney. Do you mean that there should be a different level for someone who possesses a large amount of, say, processed marijuana versus the manufacturing? I'm just trying to understand what you meant.
Yes.
So like if you just possess a whole bunch, like say 100,000 pounds or 20,000 pounds or 10,000, like is there a limit that's okay if you're not growing it?
I don't have a set figure. It's just the recommendations from criminal defense attorneys that came to me recommended that we look at manufacturing different than possession.
Yeah, I think okay. Well,
frozen or maybe.
So then can I ask a question on that? Oh, no, I see Emily's hand before mine.
I have a comment on a different section. I just wanted to get in the queue.
Okay. Mine's on this topic.
Go ahead, Representative Morgan. Thanks.
Thank you. So I guess my question would be, well, and it's kind of along the lines of the sheriff's question. So if I'm just transporting, I can have a lesser offense than the person who grew, or is the person growing have a lesser offense than the person transporting? And I guess in the hindsight, delivery of controlled substance was always a higher category than possession of a controlled substance. So which level does it become possession? Which level does it become that you are possessing with the intent to distribute? Or you just came off the farm and you're just possessing a U-Haul truck full of processed, weeds. So I guess I'm just trying to figure out what exactly are you trying to define, or the difference, or at which level? Is this a matter of I have something in my car at a level of personal use? I mean, that's just not what we're going after. This is all related to the drug trafficking and all that. So, and I see DA Eastman in there too.
Looks like Josh has some comments on this issue as well.
Yeah, I don't want to cut mine are directly to Rep Morgan's about possession, manufacturing, and I guess what it is in practice. So manufacturing is more than 12 plants typically, and then if there's 3 or more of those 10 sub-factors, it becomes a commercial marijuana offense. Possession is typically, at least that I see, it's either more than 64 plants, and then the same factors, or more than 8 pounds usable. And we see, I think last week was 1.5 tons. And I mean, hundreds of pounds daily. So, but with regards to delivery, I don't know about Jackson County. We haven't charged a delivery since Hubble, and possession with intent, it's harder to prove, and under current Oregon law, commercial possession is more serious than commercial possession with intent to sell. So delivery doesn't exist anymore unless we have an actual, at least in the cannabis world. So it's either possession and it's a lot, or it's growing, basically.
Great, we have another hand up and I can't quite see who that is.
It might
That
be
was-
mine. Thanks.
Emily.
Yeah, go
Thanks,
ahead.
Tisha. Just since we're on the topic of the possession or the quantity, I just thought I'd just briefly flag, I think it's in section 7 through 9, there's the underlying conduct of large amounts of marijuana, or if it's conducted in conjunction with specified violations. And regarding the conduct in conjunction with specified violations, since folks are having a discussion, I just thought I'd flag that those sections didn't appear to have a quantity amount. And so with regard to the amount of marijuana, if it was found in conjunction. So since we're talking about quantities or amounts, I just thought I'd flag that. Again, just putting it out there as an observation.
Yeah, and that's a good point, Heidi. And that's the same observation that we had with the other section, because if you look, the enhancements, one classification of enhancements is more than 32 times the applicable limit. That gets you up to level 4 potentially. And then the other ones aren't really based on volume. They're based on whether you're committing environmental crimes, labor trafficking, all the other things that we've heard about. And those would kick you up to potentially a 6 or 8. So that's the same basic structure that we talked about previously. So that's a good point, Katie. Josh, you got something else? Okay.
No, I always forget to unraise.
Yeah, it's those hands. All right. Anything else to talk about on those 3 issues before we move to Tyler's next issue? Unless Courtney has something. I think you got through all 3 of yours, Courtney.
Yep, I got everything. Thank you so much.
Great. Okay, it looks like Kurt's got something else.
Yes,
Go ahead.
sorry, Rob, thanks. I'm just trying to understand the numbers thing that Katie was just mentioning. My understanding of the ties to the environmental and the persons trafficking crimes is based on how you worded it for the subsections. We only get to those additional 6 or 8 if it meets the numbers that are already in the identified subsections, like possession of more than 32 times or manufacturing of more than 100 plants. Because that seemed like the way that you structured sub 5 of section 10 was that it's only a crime category 6 if it meets those numbers, and then it has the additional facts. Does that make sense?
Does to me. Does anybody have any other questions about that? All right.
I don't have,
yeah,
I don't have
go
any
ahead.
questions,
Yeah,
but I just
yeah,
had
the next
a
one. Go ahead.
quick comment on section 10 under kind of the subsection 5, page 15, the labor trafficking portion. I didn't see any mention of like threatening to withhold wages or withholding wages. And I think I know I'm kind of new to this subcommittee, so I don't know if that's something that's been previously discussed as possibly including, but coming from that aspect of things, I think that could be an important aspect to include there, that type of language.
Kurt, what do you think about that? Do we have anything that we can tie that in? I hate to put you on the spot, but
No, and I was pulling it up. I got this language from our human trafficking, another committee group that works, has different members, including our special agent in charge, as well as J.R. Ujifusu from Multnomah. And he's the one who suggested a lot of this language, and I probably pared it down too much. And I bet you he did include that threatening to withhold wages rather than just reporting. So I think it probably could just be added as one of the sub factors under capital A there in sub 5. lowercase a, capital A, and then depending on which Roman numeral list you get to, but the ones that are related to engaging in services. I just want to have one question though for Emily, since we weren't able to find someone in DOJ that was willing to comment on it. If you had any other additional comments on the BOLI side of it, as well as the that, we would certainly be interested in hearing additional factors that could help us make this kind of determination.
Yeah, that's the only other one I could think of off the top of my head. I'd have to do a little bit deeper dive, but I think if you've had kind of input from someone who deals with kind of the human trafficking aspect, I think that's probably covers things. I just know that often there is also that threat of withholding wages or non-payment of wages. And if people are stranded, I mean, it's kind of a whole factor, but I think that's one additional thing that could be fairly easy to have evidence of from workers potentially. But if I think of other things to add, I'll certainly chime in.
Yeah, I think we were trying to bridge the gap between not creating this as a straight up labor issue, but also throwing it more of the human trafficking piece, which is why we were focused more on the threatening to withhold the necessities of life, right? Lodging, food, etc. But if you could find a way to maybe flesh it into maybe that same section, Rob, right? Wages that are necessary to the life, maybe that would be the best way to tie it in without putting it in a purely labor issue. But also, Emily, if you have a little peek on way down there, there's a capital B for the violation related to occupational safe and healthy health laws, then that'd be another area that maybe if it's a violation of a BOLI issue related to the OSHA side of it, then it would also be there as well.
And I will just say, BOLI enforces regarding wages, it's ORS 652 and 653. So 654 is not our jurisdiction.
Straight OSHA side of it, sorry.
Yeah, no worries.
Great. Does anybody have any questions or comments about Emily's suggestion? If not, Kurt and I will, with Emily's help, build that fix in.
The only thing from an enforcement standpoint would be hard to, I think there's a lot of civil mingling there. So that would be just how you craft that is going to have to be pretty specific, I think, because it's going to be hard to prove what the arrangement was upon the initial agreement to provide labor for whenever the payment. So I don't know. That's just going to be a hard thing to prove, I think, criminally, but it doesn't hurt to give us some tools.
I tend to agree, Sheriff. It's going to be very difficult to prove beyond a reasonable doubt, that kind of stuff. But it is kind of the heart and soul of a piece of what we're doing here. All right, I'm not seeing any other hands raised on that issue, so it seems like we got a consensus around that. Maybe we can go to Tyler. You want to talk about sections 11 to 15?
Yeah, if I could, speaking to my command, the people who run this agency, and just really kind of thinking about this, I believe the whole cleanup component, the sections 11 through 15, we find to be very important, but it tends to be focused on law enforcement, and we don't see this as a law enforcement function. We don't see where our authority comes for cleanup and supervising the cleanup outside of this particular bill, and frankly, it's not something that we would really have the capacity to do. And because of that, we are worried about our liability, not only legal liability, but just the perception. If Sheriff Sickler is doing a great job of cleaning up all the messes he goes to, and we don't have the capacity to do it, we really think like it would look bad on us for not having the ability to do it. Obviously, counties work closer with their county works department. We don't have such a close ability to work with those outside agencies. So just wanted to bring that up, mostly as food for thought, because I don't have any solutions, and I really hate to come with just problems and no solutions. But I think one thing that I haven't really fleshed out that could help is is pointing out that it would be a government ability and not just a law enforcement ability. So this could be something that could be done by DEQ. There's a host of other agencies that aren't the state police. We just don't have the professional staff to support it or the investigative staff to support it. And then the other issue that we working with DOJ, we realized is, we're there, the vast majority of these as a part of a search warrant. And once we've collected that evidence, our ability to remain there is, in our opinion, no longer there. So if we've collected all the evidence and we've done our investigation, and now we're just waiting on a cleanup, we're not sure where our ability to remain on that private property would be. So that becomes problematic for us. And then we appreciate the discretionary portions of it, where it says we may clean up, we may lean, and all of that stuff. But again, we're just looking for some immunity if we're not able to clean it up. And not only legal immunity, but that perceptive portion of where we're not able to do it. So,
Sheriff, any thoughts?
Yeah, I think the original intent with this piece was to be able to use heavy equipment to dismantle grows and not be necessarily, I guess, liable for the destruction of these, readily made hoop houses, so to speak. So I do agree. We don't clean up everything spotless when we leave. That's not the intent, again, and I don't want to be pinned down to that either, because we don't have the resources as well, and we don't have the expertise to do that. So I don't know if there's a way to maybe, alter the language, take some out, but really that the big piece is the efficiency and the I guess making it better for the deputies, the state police, the police officers who are out there doing this work, because it is hard work and the equipment does not impact our staff as negatively. And it's safer for them to use heavy equipment. So I don't know how that could be maybe changed. And then I think Josephine County and DA Eastman can jump in, but I think that the cleanup should be on the property owner, right? And then code enforcement comes in behind on the backside, at least in our county, and says, hey, you got to clean this up, and if you don't, then they're subject to the civil penalties through the county code enforcement. But we just really need this avenue to where, the destruction orders that we get in court that are signed by judges, the judges are comfortable in our county and every county to say, yeah, that's reasonable. This is a drug trafficking piece of equipment, and it's created for the mere fact of further enhancing profits for drug trafficking organizations, and it needs to be destroyed so it's not used in other sites or, again, at the same site. And for the safety of the laborers and the safety of the environment and all the things. So I don't know how that might change a little, but I concur.
So actually, what both of you said kind of does resonate with me and makes sense. And this harks back to some work that we did in the 90s and early 2000s. There's actually two parts to cleaning up meth labs. There's the initial stuff that occurs under the Controlled Substances Act under 475. And there's also the obligation on the property owner to do a cleanup satisfactory and potentially face sanctions and liens. And that's under 453, as I recall. And so maybe what we need to do is shift this model to the other half and really focus in on saying, hey, if you have one of these sites that needs environmental cleanup, it's on you, property owner, and you have to do that. And the difficult part is the hook. I'll tell you, the hook on 453 is a property owner can't lawfully allow any use of that property until the cleanup is completed. They essentially get tagged with a big yellow sign that says, you can't use this property for anything until you've cleaned it up. And that's the hook, because the hook on the 475 provisions, which is essentially what I've crafted here, is that the government can lien. If we expand it from law enforcement to government, we could lien. It's just a matter of the mechanism. But I totally hear really what Tyler's saying, what the sheriff's saying. We don't have the resources to do this, to be honest. we don't even have the resources to get to all the sites that we need to address, much less do all the cleanup. But then I really struggle with then what do you do? Are you willing to say, because if you just say property owner, you got to clean it up, and the property owner doesn't, what's your hook? I guess it's code enforcement maybe, but that's more resource drain. Maybe the other answer, and maybe I could thread that needle somehow and make it look more like a nuisance abatement situation where we put the onus on the property owner. If the property owner doesn't do it, government can then go in and clean it up and lien the property as an option. Maybe that's another approach, kind of splitting the difference between the two. And I'm talking and thinking at the same time, which is really dangerous. So I'm going to stop talking right now and go to Representative Morgan.
Well, you just triggered a thought that I think there was a reason why in December we made sure that code enforcement was part of the CJC grants. Because the whole picture of the enforcement of this isn't just the law enforcement search warrants, it's the whole piece. Why water resource got money, why, we needed money for prosecution, we needed money for, all aspects of it. So it is kind of a local government aspect. And I think that wording in there to do with it as a nuisance abatement, but also we then have to be mindful that when it comes to the funding of these grants, that we have to take that into consideration as part of making sure we cover that too.
That makes sense to me because, yeah, if we did essentially empower more significant nuisance abatement through code enforcement, most counties don't have the resources to ramp that up. So we would have to really focus pretty heavily on the IMM-EGP to really do that. That makes sense to me as a practical matter, but what do other people think? If we shift gears, we don't put it on law enforcement, we don't put it on essentially the unsanctioned process. We essentially create a nuisance abatement process where it's on the property owner, and if the property owner doesn't do it, the county or city can essentially say, hey, you got to do it, and if you don't, we're going to do it and we're going to lien your property. Or at least they can threaten to do that. Whether they choose to or not is a different matter. That makes sense to everybody? Actually, that wouldn't take much work. It'd make the sections a lot shorter, actually.
It does make sense. I just don't want to lose what Sheriff Stickler was saying. We really need to have the ability to drive equipment through these. Frankly, my knees are getting old. I am one workman's comp claim away from moving out of this game and into a desk job. But there's hundreds of officers that the injuries, and if it's just from twisted ankles and everything else, the cost to the taxpayers and the cost of the bodies of officers is huge. So I don't want to derail the train here. I want to say I don't think it's a law enforcement function, but I think law enforcement really needs the ability to use more tools when we're attacking this problem. And I also want to say my agency believes the cleanup is a huge problem and a huge factor. It needs to be addressed. It's just not something that we have the bandwidth to do.
All right. Well, I recognize that's new.
One more, I know we're out of time, Rob, but if I could jump in, I just want to make sure I understand that on the state police thing. I also think it's important that we do address it still in some capacity for the sake of the citizens. That's one of the biggest complaints I hear. There was a bust and now there's just trash. And it was just left behind.
Since we're out of time, let me see if I can summarize where I think we're at on the 6th draft and see if everybody agrees on what we have consensus on. Then I think we're going to have to take a series of votes. So what I think we have consensus around is I'll go ahead and fix the technical things that Kaidi mentioned. We'll fix section 9 as Tyler explained, and as we talked about pretty extensively. I didn't see any objections to that. I'll also make the changes to sections 11 to 15 and convert them to more of a nuisance abatement process that I've described, which would shorten those sections up quite a bit. And I think we have consensus around all of that. What I don't think we have consensus around is whether or not to limit the search warrant statutes to just something more narrow. I think we'll probably have to take a vote on that. I don't think we have consensus around adjusting the CDO statute right now in this context. And I think that's kind of where I've captured it. Does that make sense to everybody? We probably ought to have a couple of smaller votes on the two issues that Courtney raised before we can actually decide whether to move forward with the rest of the draft. That sound all right to folks? So I think I'll probably turn it to you, Courtney, if you want to make a suggestion to confine, if you want to make a motion to confine the search warrant statutes and the amendments to some subset of crimes. We'll see if that motion flies, and then we can move forward to the next issue, if that makes sense to folks.
Before we make a motion, I am concerned that DA Eastman got kicked out of the meeting and is not able to rejoin and has been a part of these conversations. And so I hate to have us have a vote without, I mean, I get it, but I'm just saying I thought we were ending at noon and I said, don't worry about it because we're ending at noon. And anyhow, I'm just throwing that out there.
About that because we actually have to make an affirmative recommendation to the full task force tomorrow. So we just don't have time for another subcommittee meeting. So Kaidi's got a comment or a thought or suggestion.
Just a comment, which is OJD is so honored to have a seat at the table, but I just want to put it out there and just be very candid that OJD would be coming in neutral at this point in time. And so as we're going around taking votes, I just thought I'd just put it out there. OJD is neutral.
I understand. I didn't anticipate anything else from OJD. That's perfectly fine. So does anybody want to make a motion on any of the suggested changes that Courtney made? Because I didn't feel any consensus around any of those. And there will be plenty of time to battle those battles out. Does anybody want to make a motion to move forward with the sixth draft with the consensus changes that I've described?
I'd make that motion.
So
and I'll second.
Okay, a motion from Representative Morgan, second from Sheriff Sickler to move forward with the sixth draft with the amendments and tweaks that obtain consensus here today. I'll create a seventh draft to reflect those with the assistance of virtually everyone on this call. Is there any further discussion? If not, Tisha, if you want to take the roll.
Senator Przanski? You may not be on here anymore. Representative Morgan?
I vote aye.
Sergeant Bechtel?
I vote aye.
Rob Bovet?
Aye.
Josh Eastman, if he's back? He's not. Okay. Justin Dillon or Jake Johnstone?
Aye.
Kurt Miller?
Aye.
Courtney Moran?
I abstain.
Sheriff Sickler?
Aye.
Emily Sitton?
Aye.
Amanda Swanson, if present? I believe she's not present. Scott Winkles? Somebody, here's Josh coming back in. Is Mr. Winkles still on the line?
I think he's in the car, so he may be struggling with connectivity.
Okay, Josh Eastman, do you know what we're voting on here?
I don't, but it worked. I tried 3 other times, it didn't, but now I'm back, so.
Short story is, Josh, we're voting on moving the sixth draft forward with the consensus agreed upon changes that we achieved here today.
Oh, easy one. Yes.
All right, then that's it. And
all right, motion passes, unanimous vote with 1 abstention. So I will make that recommendation to the full task force tomorrow. I can't promise that I'll have a 7th draft complete by then, but I'll at least explain the conceptual elements, just because I'm relying upon others to give me some language on certain issues. All right, well, I think that is about it for today. And I'll probably see many of you tomorrow at the full task force meeting. So unless there's other business for this subcommittee, we'll go ahead and adjourn. If there is other business or anything folks want to say at the last few minutes, raise your hand or chime in. And not seeing anything, I'm guessing everybody's hungry for lunch. All right.
Thank you,
Well,
everyone.
thank you, everyone. And we'll see you tomorrow. We are adjourned.
Thank you, Rob. Thanks, everyone.